I guess we'll get started, and this is just a training session for City Commission, Board, and committee members and city staff. And we have Mr. Weber here. Take it away.
Thank you. Good evening, Mayor, Vice Mayor, Commission members. My name is Paul Waters, and I'm an attorney with the Bowes Law Firm. I am here tonight to talk about parliamentary procedures and quasi-judicial hearings. And I'd like to just say before I get started, if at any time during my presentation you have a question, please feel free to stop. I'll be happy to answer any questions as I move along. So, parliamentary procedures. Also, a form of that is Robert Rules of Order. I think you may be familiar with that. We also have quasi-judicial hearings. Those are our topics tonight. So, parliamentary procedure is a method used by commissions, legislative bodies to facilitate meetings. And the most common compilation of parliamentary procedures, that's a mouthful, is of course Robert's Rules of Order. Now the goals of these procedures are to protect the rights of the minority, to maintain the rule of the majority, and to promote the most efficient proceedings possible. So, Robert's Rules of Orders. There are many different versions of Robert's Rules. I think you can find cartoon pamphlets and all the way to very thick books that go into great detail about what the Robert's Rules actually are. Now, some boards use to promote its goals to protect the rights of the minority, to maintain the rule of the majority, and to promote the most efficient proceedings possible. So, at every meeting of a public board or commission, there of course is an agenda that sets forth the order in which items and business will be conducted. If a board member wishes to have a subject brought up out of order, that certainly is possible. Procedurally, the commission has to vote to change the order. So if someone would like to take something out of order, just ask the chair to do so, and then the commission will take a vote. This is very important because it keeps an organized and effective meeting. And by the way, only one topic should be discussed at a time during the meeting. Of course, we're being recorded, where we have someone taking minutes, and often these meetings are transcribed. So it's very important that we have an orderly meeting and only one topic discussed at a time. A council meeting such as this is different from a social event where many people speak at once, and like I said earlier, minutes are taken and we're all being recorded, and only one person should speak at a time. So before speaking, it would be proper procedure to wait until the prior speaker is finished, and then you request that the chair recognize you so that you can speak. I often call this speak through the chair. So always get the attention of the chair and ask for permission to speak, and the chair will recognize you and call your name, and that way the court reporter or the person taking minutes will know who's speaking and what was said. Now, some items on the agenda do not require the board to take action. That's procedural things such as roll calls or invitations or city manager comments. And some items do require the board to take action. And action is always begin in a meeting like this by way of motion. Usually a city staff person will make a presentation, or after an item has been announced, a board member can state a motion directed at the subject, and if another member agrees with the motion, the member can second the the chair, at the end of the vote, will announce the result of the vote.
Are we allowed to ask questions?
Yes, sir, absolutely.
A lot of our items currently, the recommendation for the item is to discuss. So we have, regularly said, I move to discuss, and then there's a second to discuss. If there isn't a second to discuss, it doesn't get discussed. And then after the discussion and potentially public comment, then the commission has more information and decides whether to make a motion or not. Is that not, you gotta come out of the gate and say, I motion to deny, or I motion to approve, and then have discussion?
That's typically the procedure. There's usually a motion and a second, and then discussion on the motion. And if the commission members decide to change what was earlier decided, there will have to be a vote. We take it to open the item. And Ms. Bose is here. She can correct me if I'm wrong.
Yeah, often there is, and I have laryngitis, and that's the reason Paul is helping me out. But often we do have items on the agenda to discuss. And if there is a motion to discuss and a second to discuss, then you can discuss it. And that discussion takes place. And then if somebody wants to make a decision on the item or postpone it to another time, you can take the action on it. And as I think was earlier in the presentation, the whole idea about Robert's Rules of Order is that it should be used to should be used to make the discussion meaningful and to protect the rights of the minority, ensure that the majority rules, and to make sure that the meeting goes along smoothly. So there are a lot of iterations, and there's nothing chiseled in stone here. So as long as those things are respected, absolutely you can have discussion. And Robert's Rules of Order is not intended to put a noose around your neck and make you into some kind of a puppet, but it helps to make the meeting be meaningful.
So what I'm saying is, okay, so I put an item on the agenda. I have had, because of the Sunshine Law, I haven't talked to any of my other commissioners, and they're like, what'd skip up to, So instead of me being hell-bent, I moved to approve this item. I may not even get a second, which happens a lot.
Yes.
But a motion to discuss most likely would get a second, and then I could hear from my fellow commissioners in the sunshine. We could potentially get public comment, and then depending on the feelings of the commission, a motion could be made to approve or deny.
That's correct. And realize these rules are here to create a smooth meeting. And it's not strict interpretation. It is meant just to make the meeting flow and to make it organized and to make whoever's recording the meeting know what is being discussed and what the issue is. And also, as I get further on the presentation, we're going to talk about quasi-judicial hearings when it actually does count how the motions are made and seconded and then reopened.
But I agree with you in the quasi-judicial part. We have already gotten our homework on the item. It wasn't something that one commissioner brought up out of the blue that they want to talk about. It's something that's, very well delineated, and we've had chance to review it. And based on our review, the motion could be to approve or deny.
Yes. I don't think there's any issues at all with board members discussing the item before a vote is made, and that's typically the case. So you don't have to make a motion as soon as the agenda item is announced. The board members can certainly discuss the item, and after discussion, then a motion can be made and seconded, and then there can be further discussion if you want.
So are you saying that we should not have a recommendation on an item to discuss, and then to make a motion to discuss, and a second to discuss, and then a vote to discuss? We should just, the item comes up, and we discuss it no matter whether anybody wants to discuss it or not?
Well, again, these rules aren't written in stone, and often these agenda items are the result of, say, a staff presentation. So certainly the staff, you would hear what the staff would have to present, and then the commission is absolutely free to discuss the item before they vote on it. There's nothing set in stone that says you can't do that.
Okay.
Does that answer your question?
Give me some more information, thank you.
Yes, sir. All right, any other questions?
So, the motion and,
Yeah,
and
that's
Robert.
this chair, so this is Ray Taylor.
sorry.
Yep, that's fine, it's a workshop.
Okay, so basically the way the agenda always reads, and the commissioners, the purpose of making the motion is just to open a discussion. If you say, I move to approve, doesn't mean you're supporting the item, it just means that you're opening the discussion. And you get a second, and, you know, frankly, I'm just like, if you wanted to say, whether, if it's stated in the affirmative all the time, then it's very clear to the public and everybody else, when they take the vote, whether it's yes or no.
Well, here are some issues with that,
Okay.
with affirmative motions. You obviously there's due process issues, because often affirmative motions, and here's the scenarios. With the affirmative motion, a board member or commission member will move to approve automatically. That's the default. If it's seconded, there's no issue. The item is approved. Where the issue arises is when it dies for lack of second, because then you're left with an open agenda item. And when you have a quasi-judicial hearing, you have two options. You can approve or you can deny. And oftentimes affirmative motions leave you with an open item that hasn't been disposed of properly. And here's another issue with affirmative motion. Let's say, for instance, you know, and this may be a silly example, someone files an application to put a nuclear storage facility right in the middle of downtown. So under the affirmative motion process, that would force a commission member to move to approve the application to put a nuclear storage facility in the middle of downtown. And obviously, the other commission members won't second that. That will die for lack of second. But that commission member will forever be on record moving to approve a nuclear facility downtown. And I promise you, with the internet, that will always be held against that commissioner if he ever runs for election in the future. That will be used against him. So, for these types of hearings, the preferable way is not to, especially for quasi-judicial hearings, it's not to start with an affirmative motion.
Could I insert myself in this? It really, from a legal standpoint, it doesn't matter on legislative actions, whether you always do an affirmative motion. Sometimes it might be a little tough to get somebody to want to make an affirmative motion on something. But on quasi-judicial, and some of our boards are just quasi-judicial, it's absolutely imperative under the case law that that it be very direct as to whether something is approved or something is denied, and it is preferable to have the reasons for the denial. So if something is going to be denied, if there's a motion to approve and it doesn't pass, you do have to go back and have a motion to deny on a quasi-judicial, because from a due process standpoint, they need to have an answer. The only exception to that is, and this does happen in Cocoa Beach, when there is a requirement for unanimous vote or requirement for a supermajority. If there is a motion to approve and it doesn't reach that level, if it's not passed unanimously, or if it is not have a supermajority, you don't have to go back and have a motion to deny. But I have most of the litigation that I have for Cocoa Beach are petitions for writ of certiorari on quasi-judicial actions, and we haven't lost one yet, and the reason for that is at the hearing, the foundation is laid and the appropriate motions are made with the reasons for a denial. And same thing, the most recent petition for writ of certiorari was when a neighbor appealed the decision, and the decision was to approve. So if the approval had not had all the information on the motion to approve, it would be much more difficult to defend it in court. So, as I say, I don't care what you do in legislative or administrative issues. Doesn't matter to me. All the motions can be in the positive. But on quasi-judicial, we need to draw that line and make sure that we're establishing a record on appeal.
So an affirmative motion in a quasi-judicial hearing is setting yourself up for failure if the case is appealed. So, anyone else have any questions about motions, affirmative motions? So if the board member wishes to amend a motion prior to a vote, the members must say, I move to amend the motion by ABC. And then discussion as to the amendment can take place, then a vote is taken first on the amendment. If the amendment passes, then a vote is taken on the main motion as amended. If the amendment fails, then the vote is taken on the main motion.
Does the amended motion, doesn't it require a second?
Yes.
It doesn't say that on your chart.
Any motion requires a second to pass.
That's my error. I created that.
Thank you for pointing that out. We'll add that to the slide.
Absolutely.
Oh, yes, sir. Too far away from the mic, he says. Questions about confusing motions, which I think is what we're doing here. Sometimes, particularly when there has been an amendment to a motion, there can be some confusion as to what is meant by the amendment and how it affects the main motion. Members should not hesitate to ask for clarification. You could ask the city clerk, you could ask the city attorney, or the city manager as what the meaning of the motion or the amendment is. And if a member has any questions about the meaning of the motion, an amendment or the ramifications of that, the issues should be dealt with prior to a vote. So if a board member who votes on the winning side of a motion in the same meeting wants to reconsider the subject matter of the vote, the board member may move to reconsider the motion. And that must be seconded before it can be discussed. And after the motion
isn't there a time lag there where you can actually, at the following meeting after something passes, that, let's say you got additional information and you
No?
wanted to ask for reconsideration on something you passed a week ago or 2 weeks ago, it's still legal, right?
Well, again, legislative versus quasi-judicial. For a legislative issue, everything has to be noticed. So if it is properly noticed, then it can be brought up at a later meeting. It probably wouldn't be the best forum to reopen an item at a future meeting without it being properly noticed and so that the public can take participation. That's for legislative issues. For quasi-judicial issues, absolutely not. It would be a terrible idea to reopen the issue at a later hearing, or even in the same meeting, motion to reconsider, because as this slide demonstrates, let's say the person who, the applicant, for example, is heard at the beginning of the meeting, his hearing is over, he leaves or she leaves, and then later on a commission member votes to reopen the issue. Well, the person with the due process has left the room. And if you vote on that issue without that person in the room, you've just violated his due process and you have lost that case on appeal.
Okay, in a non-quasi-judicial item, okay?
Yes.
Let's say we all thought this was pretty straightforward, we voted for it, it was advertised as being on the agenda, through our regular website.
Yes.
It wasn't something that legally had to be required to be advertised, okay? And then we all go home and our email boxes get flooded with, what kind of crazy stuff are you guys doing up there? You might want to relook at this. I don't think it's a great idea. And you come back in 2 weeks and you're saying we would have to, well, we could put it on the agenda to reconsider.
Yes.
But you can't just,
Just add, it would be a bad idea.
okay, so you put it on the agenda, the non-quasi-judicial agenda,
Yes.
and you say, hey, I've got a bunch more information, I'd like to put this on the agenda to have the commission consider to reconsider this item.
As long as it's properly noticed and it's on the agenda and there are no other legal issues, then yes, an item
I
can
think,
be brought back to a future
and I
meeting.
think our current bylaws, Lori, say that we have to do that at the following commission meeting, or your opportunity to reconsider is toast.
And of course, it would have to be noticed for the following meeting, so.
Well, it wouldn't have to be legally noticed if it wasn't a quasi-judicial item, unless it was for heightened density or something that has to be legally noticed.
I think Ms. Bose has a comment.
Okay, if, by notice, I think he's talking about putting it on the agenda, which could occur even as late as the morning of that meeting.
Understood.
So it should be put on there. But, on legislative issues, even if you pass an ordinance, you can bring up at the very next meeting, maybe this wasn't a good idea, and you can pass another ordinance. So, things are not, so many things that governments do are not chiseled in stone. When there are some things other than quasi-judicial that are chiseled in stone, like contract approvals. If you approve a contract for something, best not to come back the week later and say, oops, we don't want to do that.
Yeah,
Because
yeah.
there are third-party rights involved.
Okay. Okay, all right.
Okay, so there are some instances when it's appropriate to postpone a hearing until a later date, particularly when a hearing has been advertised, it's necessary, so as to not create a situation requiring a new advertisement that a matter be postponed to a time certain. So in those instances, it is appropriate to take a motion to postpone second and vote is required to accomplish the postponement. So quasi-judicial hearings,
I think you missed a slide.
did I think I
Yeah,
went,
go
what did I do?
backwards.
I went back one.
Caveats, I think this is an important one.
Okay, I missed this one. Okay, so if a matter is legislative and not quasi-judicial, a reconsideration of a motion can be accomplished whether or not people from the audience who spoke on the subject have left the meeting. However, that should only be done very cautiously since those members of the public might appropriately feel disrespected by such an action. And this is what I was talking about earlier, reconsideration of quasi-judicial decision at the same meeting, particularly after an applicant has left, could potentially be legally problematic and result in due process issues. And this slide, so quasi-judicial hearing. So under Florida law, there are times when a board acts in a quasi-judicial manner. And that's when you act as a judge, similar to a judge. Might act in a hearing. So all matters that come before a board are either considered legislative or quasi-judicial. And the city attorney will usually typically mention that particular item, whether it is quasi-judicial, since different rules apply to quasi-judicial hearings. So the city attorney will usually guide those quasi-judicial hearings. So what are examples of quasi-judicial matters? Variances, rezoning, site plan approvals, special exceptions, conditional uses, development approvals. Examples of legislative matters, amendments to comp plans, amendments to code of ordinances, amendments to the land development code, budget matters, many resolutions, purchasing decisions, vacations of right of way, and donations. So one easy way to think of it is a quasi-judicial hearing deals with a specific issue, parcel, piece of property, individual. A legislative issue deals with much bigger issues that may touch more people in the community. That's not always the case, but that's a general rule. Now, use of a script and swearing of witnesses. You'll notice that in most quasi-judicial hearings, the city attorney, the mayor, who acts as the chair, and the clerk will use a script. And the reason for the use of the script is to ensure that if there is an appeal of the quasi-judicial matter, all requirements to afford due process to the applicant have been met. The script also gives the people who are attending the meeting a description of what testimony will and will not be considered by the board or commission. All witnesses must be sworn in by the clerk prior to testifying at a quasi-judicial hearing. Ex parte disclosures. So these disclosures will be made, must be made at a quasi-judicial hearing. At the beginning of the hearing, all board members must disclose any contacts or information the member has received prior to the hearing. That includes emails, conversations you might have had, site visits, or anything else that might have provided you information that is outside of the meeting on the issue. Board members may not use information not disclosed at the hearing to be a basis for or to affect your vote at the hearing. Does anyone have any question about ex parte disclosures?
So the timing of that disclosure, okay? So, okay, yeah, I got some emails, I talked to the applicant, I did a site visit, and then you go on and you're having a hearing and something, and then there's something else that you didn't previously disclose. It's too late to disclose it, so therefore you can't include it in your discussion.
It's if you make a mistake and you leave something out, just as soon as possible, you should bring it up.
Yeah.
Right, but if you go by the letter of the law, that last slide, it basically says that you can't bring up anything.
Oh, no,
where
I'm
board
sorry.
members may not use information not disclosed at the hearing. So, I mean, if I'm like, oh, I forgot, I talked to this person,
Sure,
and it would have no effect on the vote of the hearing.
I understand it, and we could probably clarify that in the
Okay,
slide.
and actually, the purpose of that last sentence is that you may have seen something on the site and realize when you're making your decision that this is really important to you, what you saw at the site. You need to bring it up at the hearing, you know, ask questions about it so that it is actually part of the hearing transcript. Because you can't make a decision based upon something that is not brought up at the hearing.
Okay.
That was the purpose of that. In other words, if you saw something and there was a presentation by the applicant, you can ask the applicant, but, you know, when I went out there, I saw this, how are you gonna deal with this? Because that's a problem for me. And get them to, you know, give the information. That puts it in the record, and then you can make your decision based upon that. But if you didn't bring the subject up, and it never came up in the hearing, technically, you're not supposed to use that as a basis for a decision.
Understood, thank you.
So, an overview of quasi-judicial hearings. They're less formal than a court case in circuit court, but they're more formal than some other types of council meetings, and they must follow the basic standards of notice and due process. And decisions must be made on competent, substantial evidence. Only competent, substantial, fact-based testimony or evidence will be considered by the board in its deliberation and voting on these items. And that is one of the legal standards, competent, substantial evidence for quasi-judicial hearings. So what can be considered in a quasi-judicial hearing? Speculation or mere opinion, not based on competent facts, cannot legally be considered by the board members in weighing their decision. Layman's testimony with fact-based support may be considered competent and substantial evidence. And very important, a quasi-judicial hearing cannot be a popularity contest. So your decision cannot be based on the number of people who are at the meeting, or who sent emails, or who are either for or against the proposal. So, questions? Anyone have any more questions? Got some great questions.
It wasn't brought up that you can't have two motions going at the same time. Is that correct?
That is correct. You
That
should
is
have
correct.
one topic at a time.
Correct. So, what Commissioner Williams spoke of earlier about making a motion to discuss is not making a motion to either approve or deny that particular agenda item, is what I'm trying to say. So, at that point, once you made a motion and got a second to discuss, you've got to close that motion out before you can actually vote on that agenda item. Because you made a motion to just simply discuss, you're not making a motion. If you make a motion to discuss, you're not making a motion to approve or deny. Just want to reiterate. So the point of the matter is, if you make that initial motion to either approve or deny, you're still going to have discussion.
Yeah.
That's the whole idea of bringing up the motion and a second. Then you have discussion, public comment, possibly whatever the commission wants to do, and how they want to discuss it, and then they vote on it.
Understood.
That makes sense, what you said.
Great comment. Anyone else? Yes, ma'am.
Could you,
Through the chair.
Yeah.
about, disposing of an item by laying it on the table, not the date certain.
What is the question?
Well, I
I think what she's saying is, we've had this problem, we're all guilty of it. Is we moved the table motion because we know we're gonna get some additional information for 2 weeks. I think that's what she's saying, is
Yes.
should we, if you make a motion to table, you get a second, you know, should you keep discussing it?
You know, again, these rules aren't set in concrete, and this isn't life or death. And it is good form that if you do close the matter, that you move on to the next matter. But certainly that does come up all the time, I'm sure, especially with 7 or 8 people that are opinionated about an issue. That probably happens very often. But procedurally, it probably would be proper to stop and to table it to the date certain that you said. But of course, there's no issue. If it keeps going, it's not gonna be the end of the world. As long as it's properly disposed of, at the end of the day, you should be fine.
Would you mind going back one slide?
Yes,
Paul?
sir. Wrong way. This
That
slide?
Last bullet point. One more. There you go.
The decision cannot be based on the number of people who are at a meeting or who sent emails who are either for or against the proposal.
I just think it's important. We represent 11,400 something people. We may have 10 people here in the room. If 8 people are for something and we start tabulating the nays and yays, that's not the proper way to govern. Our residents expect us to make informed decisions based on fact-finding and not the temperature of the 10 people in the room.
That's actually correct.
All right.
That's a good point here.
Thank you.
And case law
Thank you.
says that too.
You have a question? My question was sort of the same thing that we've been discussing, and that is if it becomes a major event where the commission feels uncomfortable for the record, you could always table it, correct?
On a quasi judicial,
Yeah.
not really.
You can't excuse me.
Okay.
Not close the agenda item, leave it open on a date specific.
Okay. No. On, on a quasi judicial action, and maybe I need to make it very clear, on a quasi judicial action, somebody has applied for something, like a rezoning or, a site plan approval. If the board considers that they are going to be getting additional information, then it could be postponed for a time certain. But ultimately, the applicant is entitled to due process and they deserve to have a decision. So,
But
if it,
can one commissioner have the right, any commissioner, to table something?
no.
I don't feel comfortable with this vote, or?
No. No, one commissioner, they can make a motion, but there would have to be a second and there would have to be a vote. So, as we talked about, parliamentary procedure is to protect the rights of the minority, but to make sure that the majority rules. So one commissioner really has, unless there is a requirement for a unanimous vote, one commissioner can completely control the whole thing. But short of that, one commissioner can't really just stop something.
Mr. Day?
Calling the question, or did you talk to that?
I'm sorry, repeat that.
Calling the question, motion to call the question?
So that's, that would be the chair asking for a vote, is that correct?
Yes, okay,
The
there
members
are,
do that?
there, in governmental groups, whether it's the city commission or, one of the other boards, Typically, you allow as long as the commissioners want to speak. I think there are a lot of things in Robert's Rules of Order that are not typically used in a governmental context, because the right of the elected commissioners or the appointed board members to say their piece typically is respected. I mean, I haven't seen that happen has there been, since I've been here, there haven't been too many attempts to just stop discussion.
No,
No,
we're pretty liberal with it.
Yeah, I mean, and a lot of Robert's rules can become very tyrannical. I mean, and you can really mess up a meeting. If somebody who's really good at Robert's rules, if a board is controlled by them, they can just stymie the whole meeting and stop the efficient operation of a board. And in a governmental context, that really isn't appropriate.
Rick Anderson.
In the event of like a regular legislative motion and not a quasi-judicial, if an item is tabled, is there a requirement for a set date for that item to be discussed again, or can it just be different?
Ms. Bose, is there an ordinance that requires it to be heard at the next meeting?
No, it can be, if it's something that's been advertised. A lot of legislative things are advertised, like ordinances. And if you're going to postpone it, you want to save the fees for the advertising, and so you postpone it to a time certain. But it's not required, but you would have to re-advertise it if it is an ordinance.
But on a regular issue.
On a regular issue,
if
it doesn't have.
Table it effectively kills that issue if it's tabled and never taken up again.
Well, I mean, it depends. If on a legislative issue, if there is not one person on the commission who wants to have it discussed again, then yeah, it died. I mean, if there is no desire to deal with something, then it'll go away.
Yeah, our practice has always been that when we table a motion, we table it to date certain, and I can't spout off the exact policy piece that tells us to do that, Lori or Becky, but that's always been the way we did it, and it was date certain, usually the following commission meeting. If there was something the state was going to provide 3 weeks from now, it might have been for a month later, but with the absence of being tabled to date certain, the item would just live with whatever vote it was, and if it was denied, it's done.
Thank you. Any other questions? I'm sorry.
So, is first reading, second reading ordinance considered quasi-judicial?
No, that is a legislative.
Okay, that's legislative, so
They can, well, excuse me. There are some ordinances which are quasi-judicial, like a rezoning of a specific piece of property.
But just in general.
In general.
Tolling the time of between the first reading and the second reading, theoretically, if you laid it on the table during the first reading, that will extend the time between the first and second reading. When you come back after you've laid it on the table during the first reading, when you come back, it's still the first reading, or would it be the second reading that you would have to take it up again?
It would, okay. If,
They
you
got
have to
it,
have,
they
you
want-
have to have 2 readings on an ordinance.
Right.
And, not all cities, but the vast majority of cities take a vote, on the first reading. I actually represent one city that just does a reading, they don't take a vote. And there's no requirement for a vote. But the vast majority of cities, require a vote on the first reading. And then, so you have to have, in Cocoa Beach, you have to have a first reading with a vote and a second reading with a vote. So it's a new, if it is postponed to a time certain, then, it would be the first reading, the second time it comes up, and then there would be another.
Is there a time limit on that?
No,
Okay.
no, there's not. And unless it's a particular, it's very unusual to have to advertise for the first reading. The advertisement is for the second reading.
So you have to advertise the first reading the second time to get it up for the meeting that you're gonna take it off the table.
No, it doesn't lose its character. If you've never voted on it the first time, it doesn't lose its characteristic as a first reading.
Anyone else?
Can I make a closing comment?
Yeah.
I'd like to make a closing comment. First of all, thank you for putting this together. Thank you for staff to setting it up, the city manager. It's just, out of 15 years, it's the first time I've been trained like this, so.
Always first.
So I was wondering, could I just, play hooky, But I understand, is this a new requirement for this kind of training?
No,
No?
no, I just thought it would be a good idea.
Oh, you just thought it'd be a good idea. So, okay. So for all the staff and the commission and Lori and all you board members, committee members, and the public that came, really appreciate it. It's obviously a full house. And, when I take training courses, they always have an evaluation at the end, and they want to know how much your level of expertise in general parliamentary procedures has increased as a result of this meeting. So I think it would be a success if everybody could say, well, I won't ask you what level you were at the beginning, but if everybody could say they think their level of expertise is raised 20%, it would be success. So. All right, we'll call it a success.
We can poll the room and see.
And by the way, there's gonna be
Hand
another,
raised.
by the way, there's gonna be another training, I think it's on the Sunshine Law, right? In February?
Yeah, ethics and sunshine.
Ethics and Sunshine Law. Wade's gonna do it, and he gets colds, he doesn't get
We
allergies.
understand the sunshine. I think we all understand the sunshine law.
But that's required by state law.
Okay,
He's new.
Tim's got it.
You've got 2 new commissioners that have never been on, had the sunshine training. So it's obviously,
Yeah.
and all the board members need it too, in particular for some.
I know, I'm just wondering why I never got it in 15 years.
You have to have it. It's required to be on the commission, have it.
The Sunshine
Oh,
Law.
ethics, yeah,
Yeah,
but not
ethics.
parliamentary procedure
No,
training.
no, yeah.
I get plenty of ethics training in my day job.
Thank you much, guys. Well done. Anybody else? Sir.
Honestly, I'm on the pension board. I thought this was very helpful in education. I
Oh,
don't know.
good.
Oh, a 40% increase there.
There you go. Thank you very much. All right.